F2A is current. March 2026. Visa Bulletin. Spouses and children of LPRs can file I-485. Now picture a family separated for years, a green card holder, a lawful permanent resident, living in the United States, working, paying taxes, building a life. And on the other side of the world, a spouse, a child, waiting. They filed the paperwork, they paid the fees, they passed every background check, and then they waited. They waited while the priority date moved forward by weeks, then slipped back by months. They waited while other categories moved, while other families reunited, while their children grew up in photographs instead of in person. Then one morning, the March 2026 Visa Bulletin dropped, and everything changed. F2A, the category for spouses and children of lawful permanent residents, went current, not advancing, not moving forward a few months. Current, fully current. That means no waiting for a priority date to catch up. That means if you are the spouse or unmarried child under 21 of a green card holder, you may be able to file your I-485, your application to become a permanent resident, right now, today, this month. But here is where most families fall into the trap. They see the bulletin, they get excited, they assume the path is automatic, and they miss critical steps that can delay or even destroy their case. Today, you're going to do something different. For years now, there have been signs, not from official press releases, not from USCIS announcements, just signals from the data, that F2A was under serious pressure. The backlog for F2A had been building quietly. Family second preference categories tend to move slowly because demand consistently outpaces the annual supply of immigrant visas. The F2A category covers spouses and children of lawful permanent residents, not U.S. citizens, permanent residents. That distinction matters enormously under immigration law. When a U.S. citizen petitions for a spouse, that case falls under an immediate relative category. No annual cap, no waiting. Those visas are always available. But when a green card holder petitions for a spouse or child, that case falls under F2A. And F2A is subject to per-country limits, annual numerical caps, and the movements of the Visa Bulletin every single month. The system has been unpredictable. Some months F2A advanced, some months it retrogressed, meaning it moved backward, catching thousands of families off guard. Immigration attorneys who monitor these categories closely recognize the patterns, the subtle forward movement across multiple consecutive bulletins, the unusual gap between the final action date and the date for filing. The inventory signals embedded in the State Department's monthly analysis. And when F2A moves toward current, when the gap between those two dates collapses, something significant is happening in the pipeline. The question was never whether F2A would eventually reach current. The question was when, and whether families would be prepared when it did. Early in the bulletin cycle for March 2026, the State Department's Visa Office released what immigration practitioners described as one of the most significant movements in the family preference categories in recent memory. F2A, officially listed under Family-Sponsored Preferences, Second Preference A, moved to a status not seen in several years. The final action date for F2A became CC stands for current. When a category is current, there is no priority date cutoff. Any approved I-130 petition in that category, regardless of when it was filed, can move forward. This is the signal that immigration attorneys and waiting families have been watching for. It does not mean the process is over. It means the door that was closed is now open, and you need to walk through it correctly. The opportunity created by a current F2A is real, but it is not unconditional. The State Department can retrogress a category at any time. That means the bulletin can change next month. It can change the month after that. USCIS operates on a specific rule. If your priority date was current on the day you filed your I-485, your case generally remains protected, even if the category retrogresses afterward. That rule is called the grandfathering protection under Section 245A and the associated regulations. What that means in plain language is this. If you file your I-485 while F2A is current, and the category retrogresses in April, May, or any month after, your case does not get rejected simply because the dates moved. You filed when it was current. That filing date is what matters. This is why the urgency is real. This is why waiting is the riskiest strategy you can choose right now. But strategy only works when you understand the requirements. Filing incorrectly, filing incomplete, or filing without the right supporting documents can result in a rejection or a request for evidence that delays your case significantly. To file an I-485 under F2A, you need to meet several core requirements. First, there must be an approved I-130 petition on file. The green card holder, the petitioner, must have already filed that petition on behalf of their spouse or child, and USCIS must have approved it. If the I-130 is still pending, that changes your options. USCIS allows concurrent filing of the I-130 and I-485 when a visa number is immediately available, which is the case right now with F2A current. But you need to confirm that option applies to your specific situation before filing. Second, the beneficiary, the person filing the I-485, must be physically present in the United States if filing for adjustment of status. If the spouse or child is outside the United States, adjustment of status is not the right process. They would need to go through consular processing at a U.S. embassy or consulate abroad. The current bulletin still benefits them. It means their immigrant visa interview can be scheduled. But the I-485 path specifically requires physical presence in the U.S. Third, the beneficiary must be admissible to the United States. That means no unresolved bars to admissibility, no misrepresentation history that has not been addressed, no outstanding removal orders without proper waivers in place. This is where families sometimes get caught off guard. They assume that because the visa category is current, the path is clear. But admissibility is a separate legal question from visa availability. If there are any past immigration violations, unlawful presence issues, prior removal orders, or other complications in the beneficiary's history, those need to be reviewed carefully by an immigration attorney before filing. Let me walk you through what the actual filing package looks like. The I-485, Application to Register Permanent Residents or Adjust Status, is the core form. Along with the I-485, most applicants will simultaneously file for advance parole and employment authorization using Form I-765 and Form I-131. Advance parole allows the applicant to travel outside the United States, while the I-485 is pending without abandoning the application. Employment authorization, the EAD card, allows the applicant to work legally in the United States while waiting for the green card to be approved. Filing all three at the same time is standard practice and generally saves time. The supporting documents required include the approved I-130 notice, a copy of the petitioner's green card, proof of the qualifying relationship, marriage certificate for spouses, birth certificate for children, passport-style photos, passport copies, birth certificates, and results from Form I-693, the medical examination completed by a USCIS-designated civil surgeon. The filing fees are significant. As of the current fee schedule, the I-485 filing fee alone is over $1,400 for most adult applicants. There are separate fees for biometrics, and the I-765 and I-131 can be filed with the I-485 without additional filing fees in many cases. But the rules around fees change, so confirming current fees on the USCIS website before filing is essential. There is also a biometrics appointment, called an ASC appointment, where the applicant provides fingerprints and photographs at a local USCIS application support center. After biometrics, USCIS conducts background checks and eventually schedules an interview at a local USCIS field office. Though in some straightforward cases, USCIS may waive the interview requirement. There is something else families need to understand about filing under F2A specifically. The F2A category has its own history of retrogression. The State Department watches visa usage carefully each month, and if demand in F2A surges, which it will now that the category is current, the bulletin can move the dates back to control the pace of approvals. This is not a hypothetical. It has happened before. In previous years, when F2A moved to current or near current status, applicants who waited even a few weeks discovered the category had already retrogressed again. The families who filed immediately were protected. The families who waited to gather a few more documents, who waited to find a cheaper attorney, who waited until next month, many of them waited themselves right out of their window. I am not saying this to create fear. I am saying this because this is the documented history of how this category has behaved. And that history is the most important guide you have right now. For families where the beneficiary is abroad and consular processing is the path forward, the current F2A status also creates immediate movement. The National Visa Center, the NVC, coordinates the consular process between USCIS and U.S. embassies and consulates around the world. Once an I-130 is approved and a visa number becomes available in the Visa Bulletin, NVC begins collecting documents and fees for the case and eventually schedules the immigrant visa interview at the appropriate U.S. consulate. With F2A current, cases that had been waiting for NVC to move forward can now progress. If you have an approved I-130 for a spouse or child outside the United States, and the case has been sitting at NVC in a documentarily qualified status, waiting for a visa number, that wait may now be resolved. Contact NVC directly or work with your attorney to confirm the status of your case and ensure all documents are complete. The immigrant visa interview abroad is a different process from the I-485 process in the United States, but the current bulletin creates movement on both fronts simultaneously. There is also a critical issue specific to children who may be aging out. The Child Status Protection Act, CSPA, provides some protection for children who turn 21 during the immigration process, preventing them from automatically losing eligibility as a child beneficiary in certain circumstances. But CSPA protection is not unlimited and does not apply in all situations. If you have a child who is approaching 21 and is a beneficiary on an F2A petition, this current bulletin is not just an opportunity. For some families, it is a deadline. Once a child turns 21, they may age out of the F2A category entirely and need a separate petition under a different category, which would restart the clock. CSPA calculations are complex and need to be reviewed by an attorney who understands the specific rules that apply to your case. Do not assume your child is protected without verifying the calculation. This is also a moment to address the broader immigration environment. Enforcement activity under the current administration has increased significantly across many areas of immigration. But the Visa Bulletin and family-based immigration pathways remain legal, established, and protected by statute. Filing an I-485 is a legal process. Pursuing your family's lawful immigration benefits through proper channels is not just your right. It is the safest path forward in any enforcement environment. An applicant who is in valid status or who has a pending I-485 has a different legal standing than someone with no pending benefit and an unresolved status issue. Knowing this does not make you a target. It makes you informed. And being informed in this environment is one of the most protective things you can do for your family. As the weeks unfold, more data will emerge about how quickly USCIS is processing I-485 applications under F2A and whether the category holds through the April and May bulletins. The State Department will release the April 2026 bulletin in the coming weeks. At that point, F2A may remain current. It may advance. It may retrogress. No one knows exactly what the April bulletin will show. What we know is what the March 2026 bulletin says right now. F2A is current. If you have an approved I-130 for your spouse or child, and your beneficiary is in the United States in a valid status, or in a status that permits adjustment, you may have an open window right now. Talk to an immigration attorney this week, not next month. This week, gather your documents, confirm your admissibility, understand your specific situation. Knowing this right now does not make you a criminal. It makes you smart. It means you are prepared. It means you are protecting your family. Share this video with every green card holder you know who has a spouse or child waiting. It might be exactly what their family needs to hear today. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.